Events happen that change our lives. Dealing with change is what we do. We discuss with industry professionals objective solutions to work through cherished items and family memories. When we go beyond the gavel, we provide tools and information to deal with these crisis times. Welcome back to Beyond the Gavel. I'm Shane Feely with Auction Solutions, and I have Monte Schatz here with Van Den Eck Weaver Attorneys here in Omaha, Nebraska. This is our session 3 of the Trust Management and Issues with Trusts and Not Having One. Welcome back, Monte.
Well, here we are, 2020, and we still have estate issues and trust issues to talk about.
Can you imagine that, right?
Yeah, but it's a good way to get the year started. And I know it sounds a little bit self-promotional, but you know, when income taxes are coming around, this is kind of the time of year, especially in the Midwest, when you're in the, you know, it's winter and you're staying inside. Got to get the taxes done, but when taxes are done, it's kind of a recap of your finances maybe for the previous part of the year, and your taxes and looking at your finances are a good starting point to kind of look at your estate plan. It might be a good time to look at it and review it. If you don't have one, it's probably time to get one in place, and if you do have one and it's been a while, might be time to review it.
Oh, absolutely right, and everybody really needs to take a look at where they're at, and do you have a plan, and do you have something going on? Is it a trust? Is it just a will? Is it notarized? Is it signed? Is it witnessed? What's legal? What's not legal? Let's say I have a will in my cabinet that I wrote 10 years ago, and since that, times have changed. Maybe I have had a death of a spouse, or you know, my kids are older and they no longer need the care and the education that they had. Say I just take that out and start writing on the bottom of it. How's that going to affect my beneficiaries?
You know, it might not if everybody's in agreement with it. And let me qualify that with, in the unlikely event that everybody's in agreement with it. You know, if all of the heirs can agree to it, the courts are probably not going to disrupt that. But the reality is what we're talking about there is perhaps looking at a holographic will or a handwritten instrument. And the thing is if you're going to write up your own will, let's say you're going to do one, and we'll go back to if you scribble over an existing typewritten one, but if you write your own will, the thing that's critical is if you're going to write your own holographic will, the Nebraska statutes outline what has to be there. It has to be completely in the handwriting of the person that wrote the will. It has to be dated, and it has to have their signature on it. And those are the 3 requirements. It doesn't have to be flowery or pretty or legalese or you know, win a Nobel Prize for literature. Okay, it just has to convey what that isn't have the you know what the intent of the person dying is. Now on written instruments, if they write in and scratch over and put new words in there, the one thing that's going to create is it's going to, on its face, create more expense if it's a will and it has to be probated. Assuming even that everybody gets along and they say, well, yeah, those changes are what they wanted, and they drew through this clause and put their initials on it. The problem is when you do that, and I encountered an estate recently where this occurred, is there's 2 ways you can probate a will in Nebraska. There's informal probate and formal probate. The formal probate requires a lot more notice, a lot more accounting to the court, and a lot more expense because it goes from what's currently a $44 filing fee to a dollar amount based on the size of the estate, which is significantly more. And the reason you have to do that is the court has to send out, the attorney has to prepare the papers, and it has to be sent out from the court giving notice that these changes were made. And then there's the burden of proof on the party advocating this was the correct will, that those scratchings and those new things that were inked into the typewritten will were the changes that were intended. And so you have to prove that up to the court and get that admitted. So you have to do that through a formal process, which is a more expensive process. So what I tell people is if you need to change your will, let's do the codicil. I know you're going to pay a little bit in attorney's fees to have a quote codicil or slash amendment to your will done. but it's going to be far less expensive than if you draw it out and redo it. Let's just do an amendment, or if we need to redo your entire will, if there's a significant amount of changes, we'll redo the whole will.
Absolutely,
Yeah.
absolutely. Well, I think that's great. What about if you're the second wife? You're the second wife and you have 2 small children, and the other kids maybe from the first marriage might be grown. Is that going to make a big difference?
The second wives club scenario. Okay,
Yeah.
yeah. It could make some difference, especially if there is, some family dynamics there where there aren't good feelings between, the second spouse and then the children of the first marriage, or if the first spouse of the first marriage is around, maybe feeding into the fire of the first children from the first marriage.
Would that happen?
Yeah, I know. Yeah, imagine that. Second Wives Club, like I said, see the movie. You'll see how that works out. But no, and let me clarify with Second Spouses Club. It's not just females that will get frustrated.
It's not.
It works both ways, obviously. But getting to the substantive point here, a lot of times, first of all, the one individual or person that cannot be disinherited in an estate plan is a surviving spouse. 2 ways that won't occur. One is if the deceased person, the deceased spouse, provided for them in the will or their trust,
Sure.
and if the amount that is left to that surviving spouse reaches a certain percentage threshold that we call in statute the augmented share. And basically what that means, that's a protected share of the assets for a surviving spouse that has to be maintained for that person. So if the will or the trust reaches that threshold percentage that's outlined in statute, then the spouse will be protected through the will. Let's say we have a absent-minded deceased spouse or a spiteful deceased spouse, as the case might be, that they decided the second spouse may have been no better than the first, and I'll fix them. I'm just going to exit this life and leave them nothing. Not going to happen.
Yeah.
Going back to the augmented share by statute, even if the person died without a will, or if they drafted a will or trust that made no provisions whatsoever for the second spouse or the surviving spouse, the Nebraska statutes kick into gear, and virtually all 50 states have similar statutes to this, where a third of the estate has to be left if there's a surviving spouse with no minor children, and then that percentage increases. I think it's 50%, don't hold me to it, but it's a higher amount that has to be left as a percentage of that augmented estate of the deceased spouse. And that augmented estate definition is very broad. We're talking about IRAs, assets and trusts, assets held by the deceased person in their own name. All types of things go into that formula.
Sure.
And the whole idea, if you think about it, when you read statutes, they look complicated and kind of in the language, augmented estate, what's augmented? But if you cut through all the legal vernacular and so forth, what it comes down to was the state's idea behind that is to have a policy that, embittered, or absent-minded spouses who didn't provide for their surviving spouses at their death wouldn't leave behind a bunch of widows and orphans with no assets available to them, and keep them off of being subsidized by the state.
That makes perfect sense. What about couples cohabiting? There's a lot more of that going on nowadays with older people than there used to be, I think.
Yeah.
How does that factor in here?
Okay. So I won't go into the ethics or morality of that.
Oh,
okay?
please don't.
Just kidding about that. But no, all kidding aside, it's probably more critical that you have an estate plan in place, because the dynamics do change there. Like I said, let's go back to you can't disinherit a surviving spouse. Well, in Nebraska, there's no recognition of a common law marriage, okay? So if you had that long-term boyfriend or girlfriend that you thought you were going to take care of, and you didn't mention them in the will, guess what? They're out. And if this was a long-term relationship, and as you said, society's dynamics have changed. We don't have a lot of people like to think in terms of the 1 or 2 year relationship. Well, some of these individuals have been cohabitating and have been a couple. They've outlasted most marriages, legal marriages, 26 years, 27
and even
years.
seniors
Yeah.
are cohabiting just to cut the bills, and they seem to get along just fine.
Exactly.
But it's Bob's house, and Betty's been living there for 10 years,
Yep.
and they're 85, and all of a sudden something happens to Bob.
Yeah, and it's commonsensical if you really think about it, because the relationship is partially obviously based on emotions, but it's also, as you alluded to, it's a financial arrangement.
Right.
Two can live sometimes more
Cheaper than
efficiently
one,
than
yeah.
two separate households. And so it only makes sense that you have an estate plan that makes provisions that for when one of them is gone, that it provides for the other. So yeah, making arrangements for, and where this of course can be difficult, but if well thought out, and again, I recommend well communicated to heirs maybe in advance of death,
Sure.
of what the intents are. Usually what I've seen, and there's all kinds of variations, some of them will leave a certain share outright. If they each had children or one of them had children from a prior relationship, now you got to figure out how to cut up that pie to make sure that your significant other, you want to make sure they're taken care of when you're gone, or helped out or subsidized at least, and still you don't want to cut out your children. And so what you see a lot of is either trust or maybe a life estate created through a deed, where that surviving spouse has the full right to maintain and live in the residence so long as they want to during their life. And then upon either if they have to go into a nursing facility, or if they move into one of the kids, or they just don't want to have the house anymore, sure. then it'll there'll be provisions that trigger that it'd be sold, and then it goes to the children,
Sure.
or it might be held. The proceeds might be used from that and invested, and the income from that is used to help out the surviving spouse. And then when that surviving spouse dies and that life estate goes away, or that life interest in the trust goes away, then it's distributed outright to the kids from the first marriage. So I mean, there's all kinds of ideations.
It sounds like you can do a lot of different things.
You can, and really, I don't like to, lay guilt on people, but shame on you if you don't make provisions for that, because that's such
Absolutely.
that's an obvious one.
Let's talk about reverse mortgages.
Yeah.
What I find out as an auctioneer, I walk in, they say, she had a reverse mortgage. She had a reverse mortgage. She's been getting a paycheck for 10 years. We don't know what it is, but we know you can't sell the house. Can you sell everything that's here, and the cars and those types of things? When I ask them to find out, of course, they don't have their paperwork, it's too big of a hurry, and then they find out that they have paid more back than the house, which has not been cared for, is worth. When is the break point on a reverse mortgage to where you go ahead and sell the house and try to make them something besides a real estate commission?
Oh boy, that's a great question. I guess what I would say is get the information as quickly as possible, preferably while the person is still alive, to see what is the burn rate.
Yeah.
How quickly are the payments being made? I mean, is it going to be drained in 10 years with this installment, meaning is all the equity going to be gone in 10 years that it's paid out? What are we going to have left at the end of the day? And
the time frame, Monte. I mean, how long? Most banks don't foreclose. The day someone dies and they're maybe have passed and you're having a service, that may be a week, 2 weeks. Banks don't come after that the minute that someone has passed.
no.
Is there like an average time that take them to, hopefully you've communicated with them before they communicate with you?
I mean, worst case scenario, if all of the surviving parties, first thing you do when somebody passes away and a client comes into my office, the first thing we're going to do, if we don't have that information already, is, what are the assets of the person? What type of assets do they have? We're going to collect. We're going to create a post-death balance sheet for them, if you will.
Okay, that makes
So
sense.
what are all their assets? What are some of the outstanding liabilities? And that isn't just because we're being efficient and service-driven for our client. We're required by statute to give notice to creditors. when somebody dies, you open the paper and you go to the, the business section or the legal section of the paper and you see this notice to creditors.
Sure.
That's what that's all about. And, and in recent, in I guess not so recent years, but in more modern times, it used to be you did a notice in the paper and, if the creditor didn't, catch it, tough nuts, you're out, But now where you have, you're collecting paperwork and you come across where one of the heirs comes in and says, what's this reverse mortgage statement about? Now you have an obligation. You have actual knowledge. The attorney has an ethical and legal obligation to make sure that there's a notice that goes out to that creditor. So worst case scenario, you're gonna send out that notice if you don't literally pick up the phone and contact them, the attorney or the personal representative themselves. That's gonna kick into place. And typically, I would say, if you're going out and doing the actual notice, even before the notice to creditors is published, you may be on the phone and have that contact made within a month. Worst case scenario, you're looking at 2 months.
If they'll tell you, that's the big thing.
Yeah.
Even in a regular real estate transaction, we have to have permission to speak to the mortgage company because they have the new rules that have been implemented in the last 20 years. So it's a little bit harder. So can you get that prepared ahead of time so that mom and dad or whoever it was can sign off that you have permission to contact these people?
But the only thing I would warn on that is that different financial institutions, because they're very sticky about privacy laws too, as you know, is if it's the last, let's use a scenario where it's the last spouse to die, so it's the second spouse to die, and they sign that in advance, and if the mortgage company knows that that person is deceased, they might say, no, we won't accept that. We got to have letters of appointment. That may be the one.
That are dated more closely to the time of death?
Yeah.
They don't accept long dated,
Right.
Oh, she signed it back in 86.
Right. Typically they're probably going to want to see the actual letters of appointment, but hopefully with a little bit of luck, you can use that, pre-death consent and see if the mortgage company will release that information.
And then I guess just determine, is there enough to sell it and give the family something rather than just, because I typically don't take them if I'm just going to get a commission.
Sure.
It's not worth it to me. They give it to the bank, and you
Right.
can't just give the bank the keys.
Right,
There's some
exactly.
paperwork you have to do.
Yeah, there's a little bit of work that
I've
goes
had
on
people throw the keys and say that's it, but
Right.
there is some of that. So talking about real estate a little bit more, what about a due upon death clause?
Payable on death or transfer on death?
Transfer on death for a house.
Yeah. There's been a real wave of legislation that's occurred in approximately the last 5 to 10 years for payable on death, transfer on death accounts. Idea being to facilitate quicker distribution of these items, perhaps avoid some probate and so forth. That's all well and good, but a couple of inherent dangers that go with these that people need to be aware of. I'm not saying they shouldn't do them, but a couple things that they need to weigh out and consider. And that is, they're not quite like the joint tenancy, but they do have some similar characteristics where it goes to this designated person on death. Okay, couple of things, and that is, to the extent that asset's held by that person during life, it's still subject to judgments and creditors' claims and so forth.
That makes sense.
Yeah, not to the beneficiary at death, but you still got some asset protection issues, so that doesn't protect that. Proper use of trusts and other types of asset protection vehicles could more effectively do that. I think the bigger practical risk you run into with these accounts is you've got these buckets that you hold, that people own during their life. Beneficiary designation accounts like 401k balances,
Sure.
IRA balances, annuities with beneficiary designations on them. You've got this payable on death, transfer on death, which again has designated beneficiaries. You have joint tenancy assets, and then you might have a trust that has specified beneficiaries on it. And then you might have, to the extent you have any assets in your own name, titled strictly in the name of the person that's passing away, you'll have assets that go into this probate estate. And to the extent that each of those instruments don't coordinate with each other, and kind of the bellwether for determining what that is, usually you'll look at the trust or the will, and usually that intent's pretty clearly made that, you know, I want my assets distributed 30% to this person, 20% to that person. Well, now if you do a payable on death and 100% of the value of the house goes to person B, and that's 50% of the estate, but in the will, it provided, or the trust, that they were only supposed to get 20%, that really raises the question. And now all this goal of having a certain either equal distribution or a distribution based on specified percentage amounts totally gets thrown off.
I'll bet.
And so that in and of itself isn't bad. You can balance that out, but again, the only challenge you have is, what if real estate booms and goes? What if that person was the person that got the farmland payable on death 15 years ago, and that thing goes the roof, and the person that has the payable on death or the joint tenancy in the bank account that was paying a whopping 1/10 of 1%, you know, all of a sudden this person's share goes like, it becomes this much, and this person's share is this, and what was once their 25% share is now a 50% share, and this person's share that was once 25% share is now 25.2%.
Yeah.
You know, you don't have the desired outcome. So that's the thing. I still think the better tool, and I'm not saying that I advocate revocable trust for everybody, but the tool that's going to give you more flexibility on that is if you have your assets titled typically in a revocable trust, and then the provisions kick in there, and then all the title to all the properties in there still may minimize the need for any probate involvement or eliminate it. But more importantly, if all the assets appreciate, now you got 25% of the appreciation of all the assets, and now you have that equal distribution.
Right.
That's
And
going to come
I
up.
do believe that most parents want everybody to be equal.
Yeah.
I have been in some events where they've cut someone out, but that was certainly between them.
Yeah.
You know.
Yeah. You know, while we're on that, because it's a real trigger point, and that is cutting out a beneficiary. Now we already discussed the you know, can't disinherit the spouse, but
Right.
the one that you run into frequently here is the child, and you have the black sheep of the family that mom and dad are finally fed up with, and they, you know, you didn't treat me well during life. You can disinherit for whatever reason. Now, the thing is, you can put a provision in your clause, what I always recommend in your will or your trust, that acknowledges that this child existed, because what you want to do, and you leave to them a nominal amount of money. And what that does is that tells the court, if it's contested, it at least tells them, it may not be conclusive they should be cut out, but at least it tells them that, ooh, this testator may have just been, you know, starting to diminish in their memory, and they just forgot and overlooked a child. If you put that clause in there, it's clearly in there. Now, those are called interim clauses, where you disinherit children. And what I will say about those types of clauses is that what I tell people is it's a hurdle for a child trying to get back into the will or trust that they were disinherited from. It's a hurdle. It's not a brick wall. It may not stop them. They may still come in and contest it. They might have some valid bases where they can overcome that, but it's certainly a significant hurdle putting it in there. So I get what I tell my clients is it's not a 100% guarantee, but it sure strengthens your case for certain if you no longer desire to leave that particular individual in your will or to receive an inheritance.
And I don't know how often that happens. I'm sure there's an average out there, but
Quite
for the
a bit,
most
believe it or
part,
not.
really?
Yeah.
Gosh, because what I usually run into is it's pretty much everybo's supposed to have a share, and
Well, let me put it to you this way.
sometimes they're all getting along.
Yeah. Let me put it to you this way. That phrase that hell hath no fury as a woman scorned, they've never seen a disinherited child.
Oh, oh boy.
Sometimes that doesn't sit real well, and if they
Yeah.
can find a way to, you know, get back and get their share, they might do it.
But don't you think mom and dad made it clear we're done with you?
Yeah, and here's another thing, and I'm glad you bring that up, because this comes back to another practical point. When you're putting together your estate plan, whether it's a will, a trust, a combination of those instruments, whatever the case may be, unless there's some really compelling reason to keep your estate totally secretive, particularly from your children, I suggest, to the extent that you don't have to keep it secret, that you might want to sit down and talk to your kids about, you don't have to necessarily give them all the intimate details, and that's up to the individual client. You may not have to sit down and show them this is what the trust says or this is what the will says, but in general, this is what I'm planning to do. The other thing sometimes that can have some evidentiary value is if they write a letter. A trust sometimes doesn't convey the sentiments. The idea is to be concise and to the point and lay out how things are to be distributed. It might not always, you can draft that in there, but it doesn't always say the reasoning behind something that looks a little bit atypical, like, Johnny gets 90% and Sally gets 10%, and Sally's going, really what's going on here? And sometimes just drafting a letter that literally goes with the trust that conveys the sentiment of what was going on here, whether it was for punitive or non-punitive measures, maybe a good reason to put that in there.
Well, Monte, thank you. Monte Schatz with Van Eck Weaver, attorneys here in Omaha, Nebraska. This is our third session of 4. Thank you for attending Beyond the Gavel. I'm Shane Feely.